The way we got here is, do you remember how I set up chapter 5? Part of chapter 5 was about transfer of title, and it was about, did you do it voluntarily, did you do it involuntarily, did you do it dead, or did you do it alive? So watch where we go with that. I want to set this up slightly differently than my slides here, okay? What I'd like for you to do is just in the margins of your notes, I want you to write 3 types of involuntary alienation during life, and then there'll be one that occurs after death. So 3 types of involuntary alienation during life, and I'm going to give you a list. You'll be better off if you don't look at the slide for a moment. The 3 types of involuntary alienation during life are: the bank took the property from you because you weren't making your payments. What's that known as? Foreclosure. Does anybody know what it's called when the government takes your property because they need it worse than you do? Anybody know what that's called? We haven't studied it yet, so it's okay if you don't. Eminent domain. Eminent domain is another type of involuntary alienation. And then the third type of involuntary alienation during life is adverse possession. So for right now, just write it down, and then we'll come back and we'll talk about each of these. And then as long as you're making that note, there's one type of involuntary alienation that occurs after you die, and that's Escheat. Yeah, so I don't love the order that they're put together here, but it's workable, okay? Is it okay now if I come back and talk about each one of them independently? Victor, you look like you have a question. You okay so far?
So you said, can you repeat those 3? So one foreclosure, right?
Yeah. Foreclosure, eminent domain, and adverse possession. Yeah, and do you understand the significance of it? These are 3 things that ways your property could be lost to you during your life. And Escheat, you can lose it after you die. You probably won't be too torn up about it though because you're dead. But having said that, I mean, it's involuntary alienation after death. I want to talk to them now in the order that they come up, just simply because it will stay in sync with your slides. You okay with that? All right, let's get started here. The first one is Escheat. Here's what I want you to write down in your notes about Escheat. Escheat means the state, in this case I'm saying the state, capital S state, the state of North Carolina in our case. The state is your final heir, H-E-I-R. The state is your final heir. All right, now be careful. As you're working with the word Escheat, make sure you run it through all lenders. You first of all have to assume someone died while owning real property. Now let me ask you this question. If you die owning real property and you have a will, who will your property go to? Technically it'll go to whoever you left it to in the will. You don't have to leave it to your heirs. You can screw them if you want to. You can leave it to anybody you want to as long as you're not violating any law. Okay? So if you die with a will, it'll go to whoever. Technically these people are referred to as your devisees. We'll get to that word in just a moment. All right? If you die without a valid will, owning real property, who does it go to then? And before you answer, let me tell you, it'll go to your heirs. The state will do a diligent search for your heirs. Just because you don't have a will doesn't mean you're going to lose your property, right? It's going to go to your heirs. Do you have a surviving spouse, mother, father, kids, brothers, sisters? I mean, it will look to see if you have someone in your bloodline that you can leave your property to. So if you die without a will, it goes through what's known as intestate succession. Don't write it down. We'll get a chance in just a moment. Now here comes the final question. If you die without a will and without heirs, now who's your property going to go to? The state. In this case, the state of North Carolina. Okay? And that process is known as Escheat. So if you ever see a test question and it says the property escheated to, who's the only entity that the property can escheat to? The state. Do you see all the things I want you to look out for there? Hey, look, if you have a will, it'll go to whoever you left it to. If you don't have a will, don't panic. It'll go to your heirs. If you have any, if you don't have a will or heirs, then it will escheat to the state. You feel okay about that? Perfect. Let's move on. Let's move on. All right, another way that you can lose title to your property is through eminent domain. Eminent domain. I like to think of eminent domain as having like 3 points to it. Eminent domain is the right or the power of the government. The power of the government to take private property, for public use by offering just compensation. The right or power of the government to take what type of property? Private property. For what purpose? Public use by offering just compensation. Now, can you give me some examples of what might be legitimate uses of the government to take property for public use?
The highway building.
Yeah. In our area, 540, come on. I mean, 540, the government didn't own that land before they started building 540. And so they end up having to take it from other people. Some of those people might not have wanted their property to be sold. And so the government has to have a process to be able to do this. So eminent domain, the right of power to government to take private property for public use for just compensation. Okay, if you ever see me counting anything off, that's probably a decent sign that that's what you need to know. Now, let me mention a word closely associated with eminent domain. If you ever see the word condemnation is the act of the government actually taking your property. So in other words, the distinction that I'm talking to you about is that eminent domain describes the right. Okay? Condemnation is the act of when the government actually takes your property. In other words, they are related. One describes a right, one describes a physical act. Does that make sense? You okay with that? Eminent domain. You lost your property. You didn't want to, but the government needed it more than you did, and they have the right to do that. Now listen, you're going to get compensated for it. Let's not get into an argument about what just compensation is. You are entitled to be compensated for your property if the government takes it. Does that make sense? Okay, good. Eminent domain. Oh, look at my last bullet point on here. Last bullet point. I forget about this until the landlord-tenant chapter, but we can go ahead and take it on now. If I am a landlord, and I'm renting the property to you, and you have 6 months left on your lease, and then I sell it to you, Gisela, right? I sell it to Gisela. Gisela takes that property with the remainder of that 6-month lease, right? Yes, an encumbrance, okay? But what if the government takes the property? No, you're gone. You're gone, sir. You're out of the property at that point. So the condemnation will, in fact, terminate the lease. Neat little factoid to make sure you're familiar with it. All right? The next one's easy. This is the one that everybody knows before you even got here. Foreclosure. And actually, at this point, we can talk about the concept of a lien foreclosure sale. Remember, we talked a little bit about encumbrances on property. So, lien. The bank put a lien on your property when you borrowed money. You didn't pay. And so, what's their remedy? What we commonly refer to as foreclosure, right? The bank's going to sell your property because you want to pay it. You didn't want to lose your property, but you stopped paying the bank. Simple enough to spot that one? Okay. Interestingly enough, this next one that we're going to talk about, pretty rare actually. But having said that, you are going to get test questions on it, so make sure you're familiar with it. I don't think they're going to be super deep test questions, but having said that, you have to be prepared for all of this vocabulary. So adverse possession. Here's what I want you to write down on adverse possession. Adverse possession is the taking of property, underline taking, through long-term adverse use. The taking of property through long-term adverse use. I know it's been a while since Friday, but do you remember when we talked about prescriptive easements on Friday, where you ended up taking an easement right across someone's property through long-term adverse use? This is different. Adverse possession, you're actually taking title to a property. Are you familiar with the concept of squatter's rights? Have you ever heard of squatter's rights? That's basically what we're talking about. Someone squats on your property for the representative period of time. They can literally take title to your property. You've done nothing illegal, but what happens is the law will actually penalize you for sitting on your legal rights. If someone's on your property without permission, they are commonly known as a what, starting with the letter T? They are a trespasser. If you don't tell them to get off, the law's going to look at it and say, well, maybe you meant for them to be there, okay? So the law will penalize you for not exercising your legal rights. Listen, if this were the SAT, which it is not, thank goodness, this is not the SAT. But you remember on the SAT they'd have questions like this. Prescription is to easement what adverse possession is to ownership. Okay, you're literally taking title under adverse possession. Now, let me talk to you, and again, I'm just making this up, so don't beat me up too badly about it, but say, how might adverse possession occur? Well, what about this situation? Two farmers own property next to each other. These are fairly large farms. X and Y own property next to each other. They're a few hundred acres apiece. One day, X decides to build a fence on his property. I want you to watch where X builds his fence. Is there any problem with X building his fence?
No.
Right here? That's his property. He can build it anywhere he wants to on his property, right? But, you see this little section right here? X no longer tends that property. He just lets it go to seed. It grows up. And so what happens is Y on his property grows like small game, small animals and stuff like that. Well, what happens in this area right here is because it's grown up, it has coyotes and animals of prey, stuff like that. And they're killing Y's animals. So Y says, I can't have that. One day, Y gets his John Deere tractor and comes in here and he starts mowing and plowing that section right there. What would Y be called the minute he drives onto X's property? Trespasser, but X doesn't say anything about it. He doesn't say you can, he doesn't say you can't, okay? Or Y just does it. You know what Y decides? He said, now that I got it cleaned up back here, it looks kind of good. Tell you what I'm going to do. I'm going to put up a couple of fruit trees. So he puts up a couple of big fruit shade trees right here on the property. Whose land is it on? X's. It's on X's land. One day, Y's ne'er-do-well son comes home and said, you know, he's the prodigal son. He has returned. And he said, Mom, Dad, I got nowhere to go. Can I live here? And Dad says this. He said, well, son, you're welcome home, but you can't live with us. Okay? You're trouble. We're going to have to take, and we're going to get you a little trailer. We're going to put it right here. Look where they put that trailer. All right? They dug them a well. They put a little septic system out here. Progress Energy has a power line right here, so they run power to that trailer. Dad knows about his son's past, so he said, that bill's not coming to the house. You need to get yourself a mailbox so they can send you a bill for your power. All of this happened back in December of 1991. Think that's going to be important?
Yeah.
It might be. That might be important as we continue to go. One day, somebody from one of the revenuers rode by. Somebody from the tax office rode by and said, hey, looks like there's somebody we're not getting any taxes from. Let's send them a bill and see if they'll start paying it. So they send him a bill, he starts paying it. That happened soon after 1991, maybe 1992 at some point. One day, X goes back there and looks, and he said, hey, what the heck are you doing on my property? You got all this stuff, my property line goes another several hundred feet here. What's going on? You know when X did this? Yesterday. What was yesterday? March something, 2018. March something, 2018. X says, Y, I want you to get your stuff and get it off my property, and I want you to go now. What's Y going to tell him? He's going to say, I was recently in Chris's real estate class, and what Chris said, if I stay here for a long enough period of time, I may be able to acquire title to this property. X says, that's the craziest thing I've ever heard. You'd think you would have learned from last week's story, but he didn't apparently. So anyway, Y says, I'm willing to go to court, and here's what I'm going to prove in court. The use of the property was O for open. Is Y trying to hide it from anyone? Clearly he's not in this case, right? The use is continuous for how many years? 20 plus years. The standard statute of adverse possession is 20 plus years. Did we meet that criteria?
Yes.
Okay? And listen guys, when we talk about 20 plus years, remember, it must be continuous use. In this case, good gosh, he's got bills coming in from Progress Energy. He has bills coming in from the tax office. He's got pretty good proof that he was there for 20 years. If you just use it for a couple of years and then leave for a couple of years and then come back and then leave and come back, you're never going to get to 20 that way. It's continuous, uninterrupted use. You feel okay about that? All right. The use of the property was exclusive. Again, it wasn't used for some type of public venue. It was used specifically for a liar's kid. It was adverse. Adverse just simply means that you're trespassing, okay? Adverse or hostile, though often used. Anytime you're on someone else's property without permission, it's adverse, okay? And the use of the property was notorious, which basically means the same thing as open. Okay, now pay attention right here, okay? Under adverse possession, do you think Wyatt has a pretty good case right here? I think he actually has a really, really good case. But it never automatically happens. If you take property through adverse possession, it never automatically happens. Wyatt is going to have to do something to get this property. Please write this down. He's going to file a suit or action to quiet title. A suit or action to quiet title. A suit or action to quiet title. And besides suit to quiet title, what I'd like you to do is, if you ever see questions or if you ever see reference to, these are suits to clear title. That's not the way I want to say it. Here's what happens. Suits to clear property line disputes. That's what a suit to quiet title is. It's a suit to cure or to quiet a property line dispute. You know, and that was real estate agents. If you're going to get that involved in this, but I do want you to put two and two together about what we've talked about over the last couple of days. Do you remember on Friday we talked about the concept of an encroachment, an unwanted intrusion from one property onto another? Do you remember how we said to uncover encroachments? Not the title search specifically, the survey specifically. Okay, the survey specifically. And once the survey's done, then if there's a title dispute, you can address it. X can say, get yourself off my property. Or Y can say, it's been 20 plus years, I'm going to file a suit to quiet title. But it's the survey that helps you understand these things. So what I want you to get out of this lesson as far as in the field, you're going to recommend surveys. And if your clients refuse those surveys, you're going to have them acknowledge that you recommended and they refuse the survey, because these things could be important, literally to the extent they could lose their property rights, or it could make their title unmarketable. I mean, there's a lot of reasons why they need to do these surveys. You're not going to do the survey. You're going to recommend that they have a survey done and they pay for it, all right? So, adverse possession. What's the standard statute of adverse possession? 20 plus years. Once you create the 20-year period of time, does Y automatically get the property? No, he's going to have to go to court and file a suit to quiet title. Will he win? I don't know, but he's got a really good case right here. Okay? If you ever want to take somebody's property from them, see if you can figure out how to pay their taxes, because that turns out to be really, really good proof if you ever end up in court. Okay? How is that? A lot of factoids. Okay? Now, there's one more that's coming up. You know what the standard statute of adverse possession is, 20 years, right? Okay. However, I need you to write this down. Adverse possession under color of title, adverse possession under color of title, under color of title requires only 7 years. Adverse possession under color of title requires only 7 years, not 20. That's a little bit easier to achieve, right? Okay. So let's talk about, there must be something important about the word's color of title. Let me give you the brief version of color of title, and then we'll talk about it just a little bit. Color of title basically means defective legal title. Color of title means defective legal title. Defective legal title. So don't write this down, just listen and see if it makes sense to you. Under adverse possession under color of title, you're acting like you own the property. The reason you're acting like you own the property is you honestly think you own the property. Why do you think you own the property? Because you have a legal document that leads you to believe that you own the property. Turns out the legal document is what? Defective. It's defective. You remember on Friday I talked about the idea that even though there's so many professionals involved in a real estate transaction, these other professionals, they're just human, right? They make mistakes occasionally, and sometimes it could be like a property line mistake, it could be a legal description mistake or something like that. What do I want you to know about color of title? Adverse possession of color of title takes only how many years? 7 years under color of title. How many under the general statute? 20. Okay? What is color of title? Defective legal title. You're acting like you own the property because you honestly believe that you own the property. All right? I am through with adverse possession. Did we talk about the types of alienation? Did you do it voluntarily? Did you do it involuntarily? Were you dead? Were you alive? Does that make sense? We've now talked about the involuntary alienations. Let's move on and talk about the voluntary alienation is my guess. Okay? Notice the next slide. Transfer of a deceased person's property. Transfer of a deceased person's property. Let me flip it. No, that's good right there. Do you see the word by descent? That means you died without a what? Yeah, you died without a will. Do you see the word intestate? Have you ever heard of a will referred to as testamentary disposition? Okay, if you died intestate, in meaning not, you died not testate. You did not have a will. That's what intestate means. Well, remember, we have to have a way of figuring out who your property is going to go to. Now, think about this for just a moment. Think about this. If you own property as tenancy by the entirety, the only real property you own is owned as tenancy by the entirety, do you really need a will to determine what's going to happen to that house? Not really, because who's it going to go to? Your survivor, in tenancy by the entirety, your surviving spouse. Okay? So you wouldn't need a will. Joint tenancy, if you had survivorship, technically you wouldn't need a will for that. It's going to go through survivorship. But if it's not tenancy by the entirety, if you don't have a will, if you don't have survivorship, then the state has to determine who it's going to go to. And it's not always that complicated. Like say if you have kids, if you have a mother, father, brother, sister, some of this is fairly simple to figure out. I had someone in my last class. She actually found out that she just inherited property. She was a third cousin to the person who had died. Okay, that's how far they actually had to go look to determine who the potential heirs were. Intestate succession. Look, outside of the word, that's all you're going to need to know. Because if you want to have some fun sometime, go look up the intestate succession laws in North Carolina. And it's kind of interesting. It says if you have this, then this. If you don't have that, then this. And it kind of goes through all the permutations. Oftentimes, I don't know if you guys are familiar with Roanoke Rapids. Years ago, they were trying to put the Parton Theater there. Dolly Parton's brother was going to open up a theater. Eventually, that kind of didn't work out. The theater was still built, but it never became the complex that they thought it was going to. It was going to be like Dollywood East or something of that magnitude. When they started doing all the research to find out who owned the land, Roanoke Rapids is just an eastern North Carolina rural town. And so you run into these properties that have been in families for generations, and people had died and not left wills. Some of them had had kids outside of their normal family units and stuff like this. I had an attorney tell me he was looking up he was doing a title search on the property, and he found 43 potential claimants on that property. At that point, he just threw up his hands and said, look, if y'all ever sell the property, let me know. If you sell it for a lot of money, let me know, and I'll finish this. But right now, I'm stopping because we're at 43 people so far that have potential claims. Why? There weren't wills, there was not survivorship, so the intestate part of it had gone through all these little permutations. So by descent, that's one. Do everybody a favor. Own property is tenancy by entirety or right of will. You're going to save the state a lot of money if you'll do that. The state doesn't want your raw property. If the state wants your property, they already would have taken it through what? Eminent domain, so they don't want your raw property. So transfer of title by will. Hey, you did everybody a favor here. When you died, you at least left a will. Okay? Transfer of title by will. Let me give you some vocabulary, level 1 vocabulary, to go along with transfer of title by will. Obviously, if you die with a will, it is said that you have died intestate instead of intestate. You died intestate. Okay? Not a big deal. Have you ever heard the word executor? E-X-E, and then some other letters. C-U-T-O-R, executor. Okay? Here's your definition of an executor. An executor is the person appointed in the will to oversee the administration of a will. The executor, the person appointed in the will to oversee the administration of the will. Have any of you ever served as an executor before? I don't recommend it. If you get the opportunity, I recommend that you deny it. Having said that, I mean, if you feel like you need to do it for a family situation, was it a pleasing experience? And it's not. I mean, it's really kind of sad when first of all, it's sad because someone died, but secondly, then you got to deal with all the leavings and stuff. And if there's something in there where someone feels like they were cheated out of their rightful shares or whatever, it can get pretty hairy. But executor is appointed. The will actually names who the executor is. This person will oversee the administration of the will. And let me ask you this question. Did you get paid for serving as executor?
No.
No. Do you realize this? Executor, when we get to the licensed law portion of this test, executors will be one of the persons who can get paid for a real estate transaction without having a real estate license. You remember the question I asked you on day one? How many of you could sell property without a license? The answer was all of you could sell it, but none of you can get paid until you get the license, right? Weirdly enough, an executor can be paid for that function, but it would need to be written in the will to say that the executor can be paid X% or whatever on this. So executor, the person appointed in the will to oversee the administration of the will, okay? Associated executor with will. Another word that you've probably seen that you may not have known the specific definition of is the word probate. The word probate, P-R-O-B-A-T-E. Probate. Probate is the judicial, in other words, by a judge, the judicial, or by a court, the judicial determination of the validity of a will, the judicial determination of whether the will is valid or not. The judicial determination of the validity of a will. A couple of things that are interesting here. One is that wills are presumptively valid. In other words, it's your property. You can do whatever the heck you want to with it as long as it doesn't violate public policy. Okay? So then the second part of that is, do you understand that the will, opening a will, is in fact a public act because there could be real estate left in there, right? And real estate recordings are public. So anyway, the judicial determination, just because you left a will doesn't automatically mean that it's going to be valid. So the courts open it up and look it up. Let me give you an example. I own property as a tenants by the entirety, okay? As tenants by the entirety, we all know what's going to happen to my policy, to my property when I die. It's going to my spouse, right? But in the will, I tried to leave it to my mistress or something like that. Well, that's a violation of public policy. And now I just said right in front of my wife that I have a mistress. I don't, Lisa. I'm just making it up for the story, for class. But anyway, if I tried to leave it to someone else, the courts would look at it and say, well, that's not, that part of the will is not valid. It doesn't make the whole will invalid, but that particular leaving would be invalid. Does that make sense? Judicial determination of the validity of a will. Good? Okay. Add a couple of other words here. Let's put the word devise. D-E-V-I-S-E. A devise is a gift of real property by will. A devise is a gift of real property by will. Gift of real property by will. Please underline the word real property. You'll see why in just a moment. Just a moment ago, I asked you the question about if I died with a valid will, who would my property go to? And several of you said heirs. It technically goes to your devisees, the persons that you left it to. Not necessarily your heirs, your devisees. That was just a point, a technical point, okay? Devise, a gift of real property by will. The person you leave it to will be known as the devisee, okay? And then, if you ever see, most of you are familiar with this word, a bequest. A bequest is the same thing, but it deals with personal property. So a bequest is a gift of personal property by will. Gift of personal property by will. The person who receives a bequest is known as a beneficiary. Okay? A bequest, you have bequeathed it to someone else, to a beneficiary. So what's the difference between devise and bequest? They are both gifts of property, but a devise is a gift of real property. A bequest is a gift of personal property by will. You okay with that? All right, I need you to listen up. I'm sorry, say again.
The individual.
That's left to? Well, you bequeath is the act, and the person that's left to is the beneficiary. Beneficiary. Keep in mind all these are level 1 words, so really just associate them with where they go will be a large part of what you're trying to do. Listen up just real quickly on this. I don't think it'll make a difference at all, but I have been told on the national exam that sometimes they may use the word bequest generically to describe any gift of property, real or personal. I have been told that it will in no way confuse you on the exam. In other words, they won't play the two off of each other. So don't panic about that. But sometimes they may use the word bequest to describe a gift of real property. Okay? All right. What got us started on that? We're talking about transfer title today. You can do it dead or alive. In this case, you're doing it dead. It's not technically involuntary, though, because you chose who it was going to go to, right? All right, at least cut that off for just a second.